Good morning, Maria.
Morning, Matthew.
And good morning to everybody that's joined us. Thank you very much for coming on to our webinar on this very sunny in London Wednesday morning. Very much hope you're all well and looking forward to a fun session with Maria and I. We would absolutely love it if this session could be as interactive as possible. So we've got a chat box, which hopefully all the attendees can see. So we can tailor the webinar to our audience and hopefully get a bit of discussion going. We'd love it if you could type in from which jurisdiction you're joining us from, what your job role is, just so we can know a little bit more about the audience. And as I say, tailor the discussion and get some interaction going. If you say, if Maria and I say anything that's unclear or you want to discuss further, please again put it in the chat box and we'll know that there's something we need to clarify or you'd like some further information on, and again get a bit of dialogue going. I think Maria and I said we were going to kick off formally at 9:05 just to allow people from around the world to join us, and also to give everyone that's joining us time to frantically get typing in the chat box.
Yeah, absolutely. And I'm multitasking today with the slides and with everything. And yesterday I didn't feel like I wanted to also start diving into the chat box and the Q&As, but I'm definitely a lot more. My technical ability has definitely improved in the last with Zoom. So yeah, I'm all in for some chat on the chat box this morning.
So Maria's got the difficult job. I'm essentially, for those of you joining from England who are used to Chris Whitty hollowing next slide, essentially that's Maria's job. So she has to work out when I finished talking, and so she's got a lot of technical stuff to juggle. But she did it with aplomb yesterday. So this is essentially the second webinar that we're doing on the subject of enforcing judgments obtained from around the world in this jurisdiction. Yesterday, Maria and I focused on the US and the Middle East, and today we're going to be examining China and Asia. And the regimes are fairly similar because it's under the common law regime. We're also going to make sure that the webinar is available on our mutual websites, so please feel free to share it with friends, colleagues, and other professionals at the end.
Yeah, absolutely. So more people are joining, so that's good. So I reckon we give it another minute or so, Matthew.
Yep, absolutely. So it's nice to see we've got people from, looks like we've got people from Dubai and Guernsey and England so far. I recognize a couple of clients from Asia as well, which is fantastic to see. Thank you very much for joining.
Okay, Matthew, so we're nearly at 5 past, so I wonder if now's an appropriate time for us to kick off.
Shall we kick off then? In that case, I'd like to welcome everybody that's joined to this joint webinar between Saunders Law and No5 Chambers. It's great looking at the attendee list both before and afterwards to see so many people from around the world joining us. So my name is Matthew Purcell. I'm a partner at Saunders Law, which is a litigation boutique in the centre of London, and I lead a team dealing with commercial litigation and dispute resolution, often with an international element with clients, particularly in Asia and the Middle East. So that's me. Maria, would you like to tell everyone about yourself?
Yes, so I'm a barrister at No5 Chambers. I specialise in commercial litigation, often also with an international element. I'm also a registered practitioner with the DIFC Courts. Yeah, so that's me.
Should we explain to our audience why we've both chosen to work together on this webinar and how our paths have crossed?
Yes, absolutely. So Matthew and I have been working together for a while on a large international fraud matter, which arises out of a joint venture agreement. We've both been working on these enforcement cases separately, actually, and we were talking about it because we felt that it raised a lot of issues, and we thought it would be a good idea to collaborate together and share our knowledge with our colleagues from all over the world.
Yeah, absolutely. And I think with London being such a big global and legal centre, we certainly think we're the right people to handle such work and hopefully share some of the information we've gleaned. Again, if you've just joined us, to set the scene, this is the second webinar we've conducted to help our litigation friends across differing time zones. Yesterday focused a bit more on the Middle East and the US, but essentially because we're talking about enforcing judgments under the common law regime, what we're going to be talking about applies to just about almost every corner of the globe as regards England. Again, we'll make this webinar available on our mutual websites so you can share with your colleagues and revisit what we discuss.
Absolutely. And the plan for the seminar today is it will take roughly 45 minutes in total for the content. And then we will have 15 minutes for questions and answers at the end. So if you do have any questions, try and pop those in the Q&A box, because it makes it a lot easier for Matthew and I to get to those at the end of the webinar. Please do ask any questions. Please do get involved in the chat box. And now throughout the webinar, I'll be going through that chat box to see any questions which are raised. We'll also be throwing out some polls. So if you can respond to those, that would be great. Let us know if you are experiencing any technical difficulties, although Matthew, it does seem to be going quite swimmingly so far.
Yeah, touch wood.
Yeah.
No matter where we are in the world, us lawyers do like a polite disclaimer. So I think I should probably finalize the introductions by saying that Maria and I definitely know what we're doing, and we very carefully prepared this presentation. But this is guidance and not intended to be formal legal advice. But as Maria said, if you've got any questions either during the webinar or afterwards, please just contact Maria and I, and we'd be more than happy to help you. This is a very safe space webinar, so whatever you say in the chat box or whatever questions you ask, there's no judgment at all. We'd simply like to hear from you and help you out if we can. So I think with the introductions and the welcome out of the way, it's over to Maria to kick us off, and she's going to be talking about the common law regime for enforcing judgments from outside this jurisdiction.
Yes, thank you, Matthew. So first of all, when might this situation essentially arise? Well, it's when you have a defendant who is based in the United Kingdom and who has assets here that we want to try and go against. So effectively, a jurisdiction will fall under the common law regime when there is no treaty in place where either party's judgments may be enforced by the other party's courts. And there are many jurisdictions actually which fall within the common law rules. And today we are looking at China, but also there is Hong Kong, Japan, Malaysia. All of those jurisdictions would also fall under the common law regime. Bear with me 1 second. I've just had a poll come up and that distracted me. Okay.
Sorry, my fault, Maria, launching a poll.
No, it's okay. I was like, how do I get that off the screen? It's gone now. So a practitioner, it's very important. When a practitioner is dealing with this, it's very important to make sure we know exactly what regime applies to the jurisdiction that we are dealing with. And there's a lot of information out there which a practitioner can use to double check the position. I particularly like the HCCH table on their website. They have a table which specifies for every jurisdiction which regime applies. You know which treaties they're signed up to and whether or not you're dealing with a Lugano situation or whether or not you're dealing simply with the common law rules. Also, there is the Standard International Forum memorandum, which is very helpful, which summarizes the position for over 30 jurisdictions. And there are lots of also specific jurisdictional guidance, particularly with the DIFC Courts, which we went into in some detail yesterday. And in addition to that, the foreign process section at the RCJ.
Yeah, I've got quite a lot of time for the foreign process section at the RCJ. court staff in this country, and I think in other jurisdictions, sometimes get quite a bad rap. And I know that they can be tricky, but the foreign process section of the RCJ are exceptionally helpful, and they recognise that procedurally, when you involve different jurisdictions, things can get a bit complicated, and they're normally really giving of their time. So they are court clerks essentially, but with a real in-depth knowledge of how to deal procedurally with international matters. So if you get stuck, it's well worth giving them a call. Under the civil procedure rules, so the rules that govern litigation in this country, you're actually not allowed to formally rely on what court staff tell you, but if you get stuck, they're definitely worth picking up the phone to and getting some pointers.
Yes, absolutely. I know a number of lawyer colleagues who have rang the helpline at the RCJ.
Yeah, really helpful.
But I know a number of people who have. Okay, so what needs to be established before a judgment may be recognised? Because obviously the starting point for this is that the judgment first needs to be recognised by the English courts here before we can then go on to deal with the enforcement of that judgment. So effectively, sorry, the poll came up again. The person against who the judgment was given was, at the time proceedings were instituted, actually present in the foreign country. So was the defendant in the foreign country at the time that the proceedings were taking place. Or if the person against whom the judgment was given was actually the claimant or counterclaimed in the proceedings in the foreign court. If the person against whom the judgment was given actually submitted to that jurisdiction by voluntarily appearing in the proceedings, or if the person against whom the judgment was given had effectively submitted to the jurisdiction of the courts of that country. And there's lots of helpful information that practitioners can look at, which sets out the position with the common law regime. Dicey, Morris and Collins on the conflict of laws is very helpful, but also the decision of Rubin and Eurofinance, which Matthew will actually go into in a bit more detail later on. What next needs to be established is that it has to be the case that the judgment must be for a definite sum of money. It has to be an ascertained amount, and an action will not be supported if the judgment requires anything else to be undertaken, i.e. specifically to do something. We had a question, didn't we, yesterday, Matthew, where someone queried, what is the position if we have a judgment which is partially for an ascertained sum?
Yeah, sort of hybrid judgment.
Yeah, there was also a requirement for specific performance under the order, and we were saying, well, as long as there's a certain sum which is quite separate and distinct from the action which has to be undertaken, then that should be absolutely fine.
Yep.
The regime also does not apply to the enforcement of any fines, penalties, or taxes in that jurisdiction, because those are affairs for that jurisdiction to deal with. The judgment must also be final and conclusive. So it must be shown that in the court that it was pronounced, that it was the final judgment, the final order which established the existence of the debt, and an appeal does not alter the finality of the judgment. Interestingly, a default judgment may also be final, even though it may be set aside later. So if judgment has been obtained by default judgment in another jurisdiction, that is something, that order can still be enforced here. And for the United States, the judgment only needs to be final in the district where it was given. So how do we start the process? And Matthew and I were emphasising this in some detail yesterday, that effectively this is the commencement of a whole new claim, and a new claim needs to be issued by filing a claim form with a statement of case, particulars of claim, also with a certified copy of a judgment exhibited with any translations if necessary, and ideally that needs to be dealt with within the commercial court in the QBD, and then it should be plain sailing. Ideally, the matter can simply move to summary judgment, but as we know, things are not always that straightforward.
Yeah, so I'm now going to talk to you about some practical points to consider before we consider issuing a claim to enforce a foreign judgment. It's probably important for me to make the point now. Some of you may know, but some may not. In this jurisdiction, we operate as a dual legal profession, where broadly speaking, solicitors and barristers work in tandem to prepare and progress disputes. So generally speaking, a solicitor will deal with the client, take instructions, and provide some initial advice, and then will instruct a barrister to draft court documentation, attend court to present the case, and to provide further advice. As ever, there's some nuance to this, but in cases such as these, we hope it's plain sailing, but as I think Maria and I are going to evidence, there are some traps for the unwary. And because we're dealing with a common law regime, it's not codified. So there's quite a lot of law to consider before you actually take the plunge and issue this claim. There are some shortcuts so that we can avoid a full trial, the most important of which is summary judgment, which I will discuss later. But of course, you first need to satisfy yourself that the judgment debtor has got some assets, which I'm now going to discuss on the next slide. So when considering enforcing and going to the trouble of enforcing a foreign judgment in this jurisdiction, it really is all about the money and making sure that there is money or assets located in England in the judgment debtor's name and control that you can attach a judgment to. For obvious reasons, there is no point whatsoever embarking on this process in England if the judgment debtor doesn't have anything in his control. So you really need to, from the outset, start taking sensible steps to assess the position. This could include asking the judgment debtor, but I probably wouldn't expect corporation judgment debtors have a habit of trying to be difficult. But a good solicitor should be able to carry out due diligence. And that would include checking company's house in respect of a company to check what its debt to solvency ratio is like, checking the land registry to see whether there are any properties owned in an individual or corporate name, or instructing a asset tracing agent. They can be very, very good at locating assets from around the world that you could attach a judgment to. It's important to remember in this jurisdiction, you're not actually allowed to check the credit file of an individual. So you really do need to sort of think outside the box and try and follow any trails you may have for assets so you can be sure that there's something worth enforcing against in this jurisdiction. It's also really worth at an early stage considering whether there's a risk of the judgment debtor dissipating the assets. This enforcement process can take some time, so you may want to consider whether a freezing injunction is the sort of application you might want to be making. Lawyers in this jurisdiction call this the nuclear option because it really ratchets up the pressure and applies a great deal of difficulty on the judgment debtor in terms of how they can deal with their assets. So it actually causes real economic pain. So it can be a very useful tool, but a court will want cogent evidence of the risk of dissipation, and a judgment debtor just not being cooperative isn't enough. And any application you make will have to be supported by full and frank disclosure. So you'll have to talk about things that both support and undermine your case in the application. The next thing I'm going to talk about is service, and I'm probably going to bang on about this for quite a long time, but that's because it really is so important in this jurisdiction. As Maria said, what you're doing is you're starting a completely fresh claim in this jurisdiction based on the judgment obtained in the foreign jurisdiction. As a result of that, you're subject to the English civil procedure rules which govern litigation in this country. And comparatively, compared to other jurisdictions, in terms of service, and I'm talking about service of the claim form once it's been issued that gets this matter within the courts, there are very strict steps that you need to take. You've got to serve correctly, you've got to serve the right person correctly, and you've got to serve within very strict time limits. And all of the rules and the procedure that you need to follow are contained in CPR Rule 6. the court is absolutely not your friend if you make any sort of defect in service, particularly if solicitors are involved, particularly if you are a solicitor acting for a company and doing this yourself. The court will not easily or happily remedy any defect in service. A top tip, an error that I see time and time again, is where a claim form is served on solicitors, whether in this jurisdiction or abroad, simply because those solicitors have currently or have in the past acted for the judgment debtor. The rules on service are very technical, but just because there is a solicitor acting on the record does not mean you can validly serve them. The solicitor will need to have agreed in writing to accept service, and anything less than that could result in a failure of service, which can be fatal. So talking now about where to serve, service of the claim form, again, vital and sometimes a difficult first step. I'm sorry to sound like a broken record, but you've really got to very carefully consider CPR Rule 6. Again, the court is not going to be your friend, so you've got to get it right. If you're serving a judgment debtor with this claim form out of the jurisdiction, my advice is that you proceed on the basis that you are probably going to need to ask for permission from the court, particularly if you're serving in countries like Asia, the Middle East, and the USA. Permission can be requested at the time of issuing. A hearing will not normally be required, and you will be on particularly strong ground if the dispute arises out of a contract which prescribes how and where to serve. So another top tip: always check the contract and see if there are contractually agreed methods of service, because the court will pay heed to those. Of course, if the debtor is domiciled in England and you can prove it, working out where to serve will be so much easier, because CPR Rule 6, again, banging on about Rule 6, but it's so important. CPR Rule 6, when serving in this jurisdiction, is comparatively straightforward. Even if the judgment debtor isn't domiciled in England, then serving them at Heathrow is not uncommon. So you may have seen this when you land at Heathrow. You will see what look like helpful chauffeur or taxi drivers holding up a sign with someone's name on. Half of those are probably legitimate chauffeurs, but the other half are probably just waiting to serve proceedings on someone who's just landed in on a flight from Buenos Aires. So personal service when someone is in this jurisdiction, whether on holiday or for business, is another quite useful way of serving someone who can be quite difficult to get hold of. So moving on, if permission is required, you will probably be making an application to the court. It will be a without notice application. It will be supported by a witness statement. You'll need to make a full and frank disclosure of all the facts in and around the case. Permission can be sought after the claim form has been issued, but that's not a particularly good idea. Why don't you get permission sorted at the same time as issuing the claim form? Then you'll have all of your ducks in a row. As I think Maria alluded to earlier, the court is going to expect to see translations of all of the relevant documents, all of your pleadings and any evidence that you rely on. And that's really important if there's any dispute as to whether the debtor's mother tongue is English. Not getting this done or choosing the wrong language or dialect can be a fatal mistake. And I heard a tale once of documents being translated into Spanish by a firm of solicitors because of a misunderstanding of the national language of Brazil. So at best, that's embarrassing, and at worst, that's a fairly severe procedural headache for somebody. So in terms of when to serve, we've dealt with who and where. In terms of when to serve, you're going to be turning to CPR Part 7. Now, at first flush, this looks very straightforward. So the first bullet point, if you're serving within the jurisdiction, so you want to serve a judgment debtor in this country, in England, you've got 4 months from the date of issue of the claim form. Straightforward-ish. If you're serving outside of the jurisdiction, you've got 6 months from the date of the issue of the claim form. If you do not effect good service within that period of time, then you are in real procedural difficulty. Now, 6 months may initially seem like a long time, but it really isn't. And one of the reasons for this is when you're serving overseas, it involves going through various diplomatic channels, and it can take a very, very long time. So the Foreign Process Office at the Royal Courts of Justice estimates that for the service of a claim form in the UAE from England, it can take approximately 8 months. And in China and Russia, the time can be at least 12 months. So this is 12 months from the date you've issued your claim form for it to work its way through the various judicial systems to actually arrive at the debtor you're serving out of the jurisdiction. So if it's taking 12 months, you're way outside the time limit prescribed in CPR 7.5. And unless you've taken preemptive steps, you're in real procedural difficulty. So what you need to do is look at CPR 7.6, which provides that you can make an application to extend time to allow for compliance with the 4 or 6 months deadlines for service. But you should either do this at the time of issuing and certainly well in advance of the deadline if you think you're going to miss it. It is possible for you to apply retrospectively for good service if you're outside of those time limits, but trust me, the court is really not going to be on your side, and that is going to be a real uphill application. And if you're running into limitation problems, then the case could completely be at an end. A quick top tip for those that have joined us who deal in non-contentious matters, you can make some of this a bit easier by in new contracts, for example, putting a clause in that says that each party can serve the other party by email. The rules on service by email in this jurisdiction are a bit complicated. It is possible, but you're going to need an agreement, either in a pre-existing contract or with the judgment debtor that they're prepared to accept service by email. Without that agreement, you cannot serve by email. So in new contracts for our non-contentious practitioners that may have joined us, put in a clause about serving important stuff by email, because again, the courts are not going to be sympathetic if you make an error, think you've made good service by email and want to rely on that. I'm now going to move on to talk about the Limitation Act, which is an act designed to send chills down the spine of litigation practitioners in this jurisdiction. And the key message here is once you have your judgment, whether you're general counsel for a big organization or a solicitor acting abroad, don't delay, because under Section 24 of the Limitation Act, you've got 6 years to issue your claim on that foreign judgment in this jurisdiction. Now, we know that Section 24 applies to foreign judgments because Anthony Clark, Master of the Rolls no less, in the case of Tasarruf Mev Duarte Sigorta Fonu against Demirel, take a deep breath, explicitly referred to the application of Section 24 in respect of a Turkish judgment, which is subject to the same common law regime that we're discussing. So move quickly, don't delay. You need to conduct your asset investigations and allow sufficient time for this matter to proceed through the courts. And even though a client who's just gone through lengthy litigation in, say, Turkey is hardly going to relish further litigation in this jurisdiction, the client's got to be advised to, frankly, just get on with it. So I'm now going to talk to you in a bit more detail about the conditions for enforcing. So these are the tests that an English court will apply, which you will need to meet before you are granted a judgment in this jurisdiction, and they're set out above, and there are 5 of them. So the foreign judgment must be final, binding, conclusive for a definite sum, and the foreign court must have had jurisdiction over the defendant, judgment, or debtor. Some of these are quite a lot easier or more straightforward than others, and this is where the traps for the unwary really do come in. And I'm sorry to labour this point, but it's really important. You are issuing a fresh claim, so you're going to need to argue the above points to convince a court to give you the judgment that you seek. So turning to the first condition, As Maria alluded to earlier, the foreign judgment has got to be final, binding, and conclusive. And the obligation will be upon you to show that the foreign judgment is all of those things. And that's founded on a principle known as res judicata, which is the finality principle. If there is any doubt, it's a really good idea to obtain witness evidence from a lawyer in the local jurisdiction, stating under oath that the judgment is indeed final and explaining why no routes of appeal exist and why all foreign domestic legal proceedings in this matter have been exhausted. If you don't have this evidence, or if there is a dispute as to whether or not this is final, the judgment you're trying to enforce is final, binding, and conclusive, then summary judgment may not be available to you, and this will lead to a triable issue, which is not what you want. What you want at all times is to be trying to proceed to summary judgment. Also, quite interestingly, even judgments that haven't actually ended up in local court proceedings or foreign local court proceedings may still be capable of enforcement. So in Midtown Acquisitions, comparatively recent case, this arose out of a judgment by confession for a debt in New York, where a debtor admits through an affidavit that he owes the money, and it's essentially an administrative judgment where a member of court staff stamps the judgment. There's no court hearing whatsoever, and then the judgment creditor has a judgment. So there are no court proceedings, but that is still a valid judgment that can be enforced in this country. So the next test is that the judgment is for a definite sum. This is typically not a particularly difficult hurdle to overcome. The majority of judgments are for defined sums of money, which a judge in this country is going to be easily able to comprehend from the judgment itself. Again, if for whatever reason the judgment is unclear, then make sure that you've got expert evidence explaining some of the nuance within the judgment, so you're not opening yourself up to an arguable point. Maria alluded earlier to a couple of things that cannot be enforced as a monetary judgment in this country, and that includes any award for unspecified damages, sums payable for taxes or other charges, fines or penalties, or an injunction or order for specific performance. By way of example, if you're legal counsel for the Boston Traffic Fine Enforcement Agency, you will not be able to use this process to obtain payment of historic traffic fines, no matter how enormous these sums are. So judgment must be for a definite sum.
Pause there, Matthew. We've had a question asked on the chat. You can just pop into that.
So Andrew asks, do the judgment regulations, so 1215 of 2012 of the European Parliament and of the Council of 12th December 2012 on jurisdiction, are they now abolished post-Brexit? You and I were discussing this yesterday, and we had a slight question mark next to this, didn't we? And we didn't think it was a definite no, they are not. But I think there's still definitely a question mark as to whether they have changed in some way. So Andrew, I think Maria and I would be very happy to follow up with you afterwards to try and bottom that out. I think if anybody that watches the news in this country, I don't know how much it reaches other countries, but Brexit's certainly causing all sorts of allegedly unforeseen hiccups. And the honest answer to this question is I don't think we yet know, but Maria and I will happily check and let you know.
Perfect. Thank you, Matthew.
No sweat. So I'm now moving on to talk about a slightly more complex limb of the test. So if you remember, the conditions for enforcement were that the judgment is final, binding, conclusive for a definite sum, and the judgment and the foreign court had jurisdiction over the judgment debtor. The issue of jurisdiction is a slightly more complex one, and typically the one where the main battleground is fought. And it's a really fundamental condition for enforcing a foreign judgment that the court in England and Wales is certain that the foreign court had jurisdiction. So I'm going to take you through that now. Different considerations apply as regards individuals and bodies corporate. It does get a bit heavy, but please bear with me. The test is set out in the case that Maria referred to earlier of Rubin against Eurofinance. And there are essentially 4 gateways to evidencing that the foreign court had jurisdiction. And the more you can get in, the more you can shoehorn into your application before a judge, the happier a judge is going to be. So how are you going to evidence that the court in China had jurisdiction over this debtor, for example? Well, the first case is fairly straightforward, and that is that at the time the foreign proceedings were instituted, the judgment debtor was resident in that country and he was properly served. If you can evidence that, and again, query whether you need evidence from a local lawyer, if you can evidence that they were properly served, then a court is and they were present in the jurisdiction, then an English court is likely to be content that the foreign court had jurisdiction. The second case, bullet number 2, is if it is the claimant in the foreign case that is being enforced against. Self-evidently, if they launched a claim in China, they would have obviously submitted to the jurisdiction by virtue of them bringing a claim. The third case, bullet number 3, is whether the judgment debtor voluntarily submitted to the foreign court. So even if there was a problem with service or the court isn't happy that the judgment debtor was present in the foreign country, then if the judgment debtor has made a voluntary appearance or made some submissions in the foreign hearing, then a court in this jurisdiction is likely to conclude that they voluntarily submitted, they participated in the proceedings, and therefore the foreign court had jurisdiction. The final case, which may be a bit easier, is where the judgment debtor had agreed before the commencement of the proceedings or pursuant to a contract had agreed to submit to the jurisdiction of the foreign country. In a lot of contracts, you will find that there are jurisdiction clauses. You might need to go further than that. You might need an admission that they are formally or have formally submitted, but that's another ground for an individual. It's normally the case that 1 and 2 are your easiest grounds. 3 is probably your next best shot, and then follows 4. So that's what you need to prove in terms of jurisdiction over an individual. If you're dealing with a judgment against a company or a body corporate, there are the tests that the courts will apply are fairly similar. And again, you're going to want to get as many of these gateways in. So the decision of Emmanuel against Simon, a case of quite some age, 1901, but still very good law, again sets out the 4 gateways or the tests that a court is in this jurisdiction is going to be really interested or going to want to see as evidence that the foreign court had jurisdiction. And they're quite similar. So 1, that the body corporate submitted to the jurisdiction of the foreign court by appearing in the proceedings, perhaps by putting in a defense or a witness statement, or there was some sort of agreement that the foreign court had jurisdictions, or where, similar to an individual, in the case of a company, that company had its principal place of business, so a main office in China, for example, or it had a branch office, a representative office in that jurisdiction. When it comes to representative offices, which aren't head offices, it can be a bit more complicated, and there's a bit more law around whether or not a representative office can truly be brought in and be shown to have the relevant jurisdictional requirements. So that's a bit of a trap for the unwary that's slightly outside the scope of this webinar. But you can see that these 4 tests are fairly similar to that which applies to an individual. So I'm going to take a deep breath and have a sip of water after that slightly heavy section, and I'm going to hand back to Maria to consider some of the defences that a judgment debtor may raise once you put in your claim.
Yes, thank you, Matthew. You definitely need a sip of water.
Yes.
Okay, so going on to deal with the defences then. So it is the case. I've got a couple of claims ongoing at the moment where defences have been filed, and it's about taking a step back and assessing if this is actually a valid defence or not that can be raised, and the circumstances in which a claim may be defended are actually quite narrow. The court will not look behind the judgment from the foreign court itself, and the court will not be looking into that judgment on the merits, on any questions of fact, or on any questions of law. But as I've said, I've got a couple of cases ongoing at the moment where defences have been filed. And so then the exercise needs to be undertaken where you need to have a look at, firstly, actually, are there any procedural defects with the defence that we can go against? First of all, because on a couple of my cases, it's litigants in person who have been the defendant. So the defence itself, there are many issues with it, but also, secondly, whether any of these defences have been set out within the defence itself. So the first one is, has there been any breach of natural justice that has taken place in the foreign court, which, for example, has prevented a party from making submissions in the foreign court, or perhaps did the defendant not have due notice of the proceedings at all? And the court here will be considering whether there has been any procedural defects which could constitute the principles of natural justice, which the English courts very much like to uphold here.
Definitely.
One of the cases that I've set out there is a case of Adam and Cape Industries, and effectively Cape Industries, they were marketing asbestos. They're a UK-based company, but they also had a subsidiary based in Illinois, and they were actually sued in the state of Texas. But the English court here found that, one, they were not present in the jurisdiction at the point that the proceedings were instituted, and secondly, they had not submitted to the jurisdiction either, so the judgment was not recognised in the courts here. The second defence that may be raised is whether or not the judgment was in fact obtained by fraud. And when we are looking at fraud, it has to be something that is really goes to the heart of the case, which was operative in the judgment actually being obtained. It's not any peripheral matters which will apply. It has to really go to the heart of the case itself. And in Gelly and Shepherd, the defendant was trying to prevent a judgment from being recognised here on the basis that in the trial in the foreign jurisdiction, one of the witnesses had made various false representations which were found to be false, but the English court here was of the view, well, there were also other witnesses which did not make false representations. So that element of the fraud did not go to the very heart of the case and the heart of how the judgment was obtained. So the judgment could still be recognised here. Public policy grounds. So would the recognition of the judgment be contrary to public policy? Would recognising the judgment here offend universal principles of morality? Do any human rights considerations arise which would prevent the judgment from being recognised here? That is also a ground. So one of the cases, a 2020 case, this was a DIFC Courts case, and Mr. Hay was actually a English national who was living in Dubai, and he was defending a claim for breach of fiduciary duty and breach of contract. And effectively in the DIFC courts, immediate judgment was granted, which is essentially the equivalent of summary judgment here. And Mr. Hay, he tried to raise all of these defences to prevent this judgment from being recognised here. He tried to say that there was fraud in the proceedings before the DIFC courts. He tried to say that also it would be contrary to public policy to have that judgment recognised, because he tried to assert that firstly, he didn't have any legal representation, and secondly, that he wasn't able to attend the proceedings. But in fact, the High Court here had due notice that on various occasions throughout the proceedings, he did actually have the benefit of lots of different legal advice, including advice from leading counsel. And he was also invited to attend the trial by way of Skype video link, and he refused to do so. So again, those objections that were raised, they were dismissed in this case.
Great, thanks for that, Maria. Well, as I think Maria's really clearly set out, actually, when you've got the foreign judgment, there aren't that many defences that a judgment debtor can raise successfully to prevent this new claim being issued and succeeding. Now remember, I'm banging on about this again, you have issued a new claim and you've got to argue that those 5 tests that I set out earlier have been satisfied. Now, given the limited number of defences, and given if you've got your ducks in a row and you've set out cogently why your foreign judgment meets the 5 tests, arguably the best way to go about obtaining judgment is by way of summary judgment, which is what I'm going to discuss now. So not every jurisdiction has this regime, but in essence, summary judgment is a route to obtaining the judgment that you need in this jurisdiction to begin enforcement proceedings. It is a much quicker alternative than going to trial, and is absolutely the preferred route given the limited defences available to a judgment debtor, again, as Maria has explained. It's important that that we remember that if we don't go to summary judgment, then this matter will proceed to a trial of issue. But summary judgment is made on the basis that, given the limited defences, that the judgment debtor's defences cannot succeed. So you need to make an application under CPR 24. You will be inviting the court to determine the dispute without a trial. And again, you will succeed on the basis of the judgment debtor's defences. Gosh, that's a tongue twister. Cannot succeed. So what is the test for summary judgment? That's set out in CPR 24.2. And the test is the defence, the judgment debtor's defence, has no real prospect of success, and there is no other compelling reason for trial. When you are applying for summary judgment, which really is what you're going to want to be doing, it's going to be necessary for you to provide sufficient evidence to satisfy the court that the judgment was, as we have discussed, final, binding, conclusive for a definite sum, and the foreign court had jurisdiction. If you're able to prove that, and you're able to disprove the defences, then hopefully you are going to be able to prove that there is no real prospect of success. There is no triable issue here, so summary judgment is what you want. It's a complete short circuit and could be gotten once the judgment debtor has been served and maybe put in a defence, could be gotten in a matter of months rather than potentially 18 months, 2 years plus if you were going to a trial. And then if you succeed at summary judgment, you get the judgment, the all-important judgment that you need that you can then go on and enforce. So let's talk a bit more about what no real prospect of success means. So there's quite a lot of law on this, as you might expect, and one of the, or the leading case is a case called Easy Air Limited against Opal Telecom. In broad terms, the prospects of success do not have to be particularly high for the defendant, but the claim must be realistic as opposed to fanciful. A realistic prospect is one that is more than merely arguable and carries some degree of conviction. But again, if you've evidenced those 5 grounds supported by good evidence from a local expert, it really is going to be an uphill struggle for the judgment debtor to mount an argument that isn't susceptible to summary judgment. As I said, Easy Air Limited against Opal Telecom, that's the leading case, but I picked out 2 cases that provide a bit more colour on how the court will approach this and are a bit more accessible. So Burndon Holdings against Fielding, which is up there, provides a bit of useful guidance. The no real prospect of success test is not going to require a judge to look at the probability of the defendant successfully defending, but the absence of reality, which I think is quite a nice phrase. And it's up for the party that's bringing the summary judgment application to demonstrate that the defense lacks reality. Once you've demonstrated that, the burden then shifts to the defendant to prove otherwise. So again, as long as you've got your ducks in a row, it's batted back to the defendant, which with the limited defences, as Maria has explained, is quite an uphill struggle. The next case I highlighted is Rich Bell Strategic Holdings, so a good piece of law from 1997, and this was given by Lord Neuberger before he jumped up to the Supreme Court. Sometimes what we see in these cases is a defendant will, in their witness evidence defending summary judgment or in their skeleton arguments, or in their defense, they will throw the kitchen sink at this matter, trying to set out how unbelievably complex the case is and how no judge could possibly, at summary judgment, even get to grips with the basic facts of this case because it's so complicated. Well, that's really the wrong approach if you're a defendant, because as Neuberger said, however complicated and extensive the evidence might appear to be, extensiveness and complexity cannot be invoked to mask the fact that on a proper analysis, there's no arguable defense to a claim, whether on the facts or the law. So just because this might be an incredibly complicated £100 million dispute involving oil fields across the globe, if you've satisfied those 5 tests, and if you can rebut the defenses, complexity cannot be used to paper over the cracks. So that's a really good bit of law to be aware of, and a really poor approach for a defendant to take. So quickly moving on to the process for summary judgment, you make an application to the court. It's an on-notice application that needs to be supported by a witness statement. The application fee for this jurisdiction is a comparatively modest £255. It'll be supported by a witness statement, usually from the solicitor with conduct, but it will be often drafted by an expert barrister like Maria, and we'll work together on drafting the content to make sure it smashes all of those points that we need to make. You will also, as I keep banging on about, you'll want to get that expert evidence from a local lawyer in the jurisdiction. Do not underestimate the usefulness to the court of evidence from a senior lawyer in that jurisdiction. Judges that deal with these matters, have experience of many jurisdictions, but you can't rely on a judge knowing the minutiae of the law in Korea, for example. So the judgment debtor in the summary judgment procedure will become the defendant respondent to the application, and they are entitled to file witness evidence in response. Skeleton arguments will be exchanged before the hearing, drafted by a barrister. But it's important to remember, again, I think I've said this, 100 times now, this is a new claim. So similar, the civil procedure rules apply, and in this jurisdiction, at all times in a claim, you've got to turn your attention to whether it can be settled. So offers of settlement, mediations, all of these things, both parties have to turn their attention to avoid troubling the court. So always consider whether, even after you've issued proceedings, even after you've issued your application for summary judgment, is there scope to try and reach some sort of alternative resolution of this dispute, whether that's through a roundtable discussion, without prejudice letters, or a mediation. So I'll now talk about the outcome of the summary judgment hearing. So again, fingers crossed, you've nailed those 5 grounds in your witness evidence and a judge is on board. If the judge is on board and you get judgment on the claim, you win your summary judgment application, you have then got a judgment that can immediately be used to enforce against assets in this jurisdiction. So fantastic, you've got a win. Not in every jurisdiction, but in this jurisdiction, the rule is that the loser pays the winner's costs. So if you won, And if the money you've spent to get to the win has been reasonable and proportionate, then you can expect a recovery rate of your legal costs of around about 80%, and the loser will be paying those. Nobody ever gets 100% of their legal costs, because a judge will always say, you spent a bit too long on this and could have done this a bit quicker. If you lose the application, then similar cost considerations apply. Regrettably, you will be obliged to pay the costs of the winner, and the judge hearing the summary judgment application is likely to order directions, so a timetable to take this matter to trial, and the matter will continue to a trial on some of the issues that the judgment debtor has raised, unless it's otherwise settled. The third option is a little bit rarer, and that is that a judge makes a hybrid or conditional order. That could be where essentially a judge is slightly sat on the fence in terms of the evidence, and orders that one party do something to either improve the quality of the evidence or perhaps pay some money into court pending a further hearing. It's slightly rarer. Normally you are either going to get judgment or you're not, but a conditional order is possible. So I'm going to hand back to Maria, who is going to talk us through some of the practical steps some practical tips that the witness statement should address when you're applying for summary judgment.
Thank you, Matthew. So I like to be quite methodical with how the witness statement for strikeout and or summary judgment is prepared. So firstly, I like to, in the statement, discuss the judgment that we are asking the court to recognise, referring to the judgment itself, referring to the certified copies of the same, referring to the pleadings, the claim form and the particulars of claim. I will then have another section where I discuss any failings within the body of the defence itself, and whether there's been any failure to comply with CPR 16.5, for instance, if you are against a litigant in person, setting out those failures to comply. I then will set out the basis upon which the judgment may be recognised by the English courts, and as part of that, I will then go on to set out what the applicable defences are, how the defendant in this scenario has failed to refer to any of those applicable defences, or they've failed to satisfy any of the tests set out within those applicable defences. And of course, referring to the relevant rules at all time, whether it's CPR 3.4 subparagraph 2 or CPR 24.2. So it's a very detailed statement, and I think it helps to go through that in a very methodical way. So once we have the judgment recognised, it's all about having that judgment then enforced, so we can take enforcement action. And that's basically that's what everyone wants to achieve. And the enforcement action that may be taken now can include things such as third-party debt orders, charging orders, orders for the possession of and or sale of land, orders requiring judgment debtors to provide information about their assets, orders appointing enforcement officers to seize assets, and any orders relating to insolvency procedures. Matthew, is there anything else you want to add on to there?
I think certainly in my practice, when it comes to enforcement, making the point to particular types of individual that a judgment is going to be really difficult for them can be quite important and can be quite powerful. So for example, if you're dealing with a solicitor or someone that's regulated by the SRA, and you're trying to enforce a judgment against them, that's quite a powerful weapon. The same applies to barristers as well. Barristers and solicitors, regulated legal professionals, get into real professional difficulty if they have a judgment made against them. So that's quite a good pressure point that you can apply on regulated individuals. For company directors in this jurisdiction, and in fact any individual, a judgment debt really does make a person's life quite difficult. It makes it almost impossible to get a mortgage, a credit card, car insurance, and in some cases, being a director of a company that has got a judgment debt against it can preclude or make it very difficult for you to become a director in the future. So the threat of an inevitable judgment against these types of individuals can be really quite powerful, and you would expect your solicitor to be making this point really quite powerfully. I also do quite like using the procedure that compels, when we're dealing with individuals, that compels an individual debtor to attend court to answer questions under oath about their assets. And that can be quite useful when you know the judgment debtor has something in this jurisdiction, but you don't quite know what or where it is. You can apply for the individual to go to court, and in front of an angry court administrator next to a judge, they will be asked questions about their assets under oath. And of course, if it turns out that they've lied under oath, then that's quite serious, and the whole process is pretty unpleasant. So that can also be quite powerful. And again, it's still never too late to think about the potential of a freezing injunction, and do not underestimate, notwithstanding the high barrier to entry, do not underestimate how powerful a freezing injunction can be. So I think that would be my views on enforcement. And I think, if I'm right, Maria, that takes us to the end of our whistle-stop tour through enforcing judgments from foreign countries using the common law regime in this jurisdiction.
Indeed, and we're now going on to deal with questions and answers. I've seen a couple of questions pop up in the chat box, but I think before we go to those, it might be good, Matthew, just to talk about some of the questions that we received yesterday. So we've already touched upon the question that arose in relation to where there's two parts to the order, how that can be dealt with. And we also had a question from a lady who was very concerned about a judgment she had from 2010. Yes. And that concerned Matthew and I as well, that she had that on her desk. And we hope that was something that she'd only just recently came across, this 2010 judgment. Because
yes. Yeah, we had the limitation regime that I described, particularly Section 24 of the Limitation Act 1980. The English limitation regime is a lot grumpier than we find in other jurisdictions. And this particular lady, I'm not sure whether she was a solicitor who'd just been thrown this file or had had it for a long time, but she was looking to enforce a judgment from America dating back to I think it was 2010, so of quite some age. And the court, frankly, apart from in incredibly discrete and unlikely areas, is ever going to allow a judgment over 6 years to be enforced in this jurisdiction. And 6 years sounds like a really long time, but actually by the time you've done your asset searching, and by the time you've given the client some breathing room after the main litigation, and by the time, if you're dealing with countries like China and Russia, by the time you've actually then get to issuing, it's remarkable how much time can go by. And trying to do this sort of work in a panic, in a rush, is when mistakes, particularly as regards service, are made, and things just go a little bit wrong. So even though you've got 6 years, I'm not saying it's going to take 6 years, but don't dally, don't let the time tick away, because trying to do it in the last 6 months is just a recipe for disaster.
Okay, great. So I've just had a look in the chat box. So let me just check if there's anything in the Q&A box. So the questions appear to be in the chat box. We've got another question from Andrew Wesson. And he says, it's so amusing we have followed all the 5 tests. The service regulation is annexed to practice direction 6B. He then refers to Article 21 of the service regulation. This would suggest that we are not a member of the EU state. We cannot enforce the order. He then refers to the CJJA Act 1982 and the Civil Procedure convention in relation to the Brussels and Lugano conventions. And he says, which of the above prevails as the legal area of law for the judgment and debtor? Firstly, I have to say I know Andrew very well, so I'm going to be messaging him after this and thanking him for these questions, because it's always good when people do throw questions out there so that not everyone is in silence at the end of a webinar.
I think this was one of the dreaded conflict of laws post-Brexit questions that we were slightly dreading, and I think my truthful answer is I am still trying to plot a course taking into account the various treaties and the law that Andrew refers to work out exactly what the position is. And I think even our helpful friends at the forum process section may just say we don't yet know yet.
Yeah, and I think that was precisely why Matthew and I wanted this webinar to focus on the common law regime.
Yes.
Hopefully being the regime which is not going to really be subject to any real change. So I think, Andrew, the simple answer to that one is we're not entirely sure of the position. And so then we've got a question from Loretta. Matthew, I don't know if you want to deal with that.
So Loretta thanks us for an illuminating session, which is very kind, and then talks about the UK's application to rejoin Lugano on the 8th of April 2020. And she asks how likely it is that we think the EU will approve the UK's application, and she believes that they'll be making a decision relatively soon on the 8th of April 2021. And then she asks, if the UK's application has been approved, could you please share how it will affect judgment recognition and enforcement in the EU and England and Wales moving forward? I think we're going to be giving a fairly similar answer to Andrew, and that is we particularly focused on the common law position because that is just not I don't think going to particularly change post-Brexit. And as regards whether or not we are likely to be approved to rejoin Lugano, I just don't know. I mean, that's such a political decision. The EU is, I think, at the moment quite grumpy with us for all sorts of reasons. The vaccine issues don't help now. Of course, decisions of treaties and law you would hope were not taken against the background of upset over short-term hiccups. But I have no idea whether we'd be joined. You can see the sense in this coming back in, but I just don't know what the mood is. I think if anybody knows Katia Adler might be the best person to direct that to. But we can certainly go away and have a look at that as well. I don't know whether you've got anything else to add, Maria.
No, I mean, I think the vibe is that we think the EU will approve the UK's application. That's what I've been hearing anyway.
Okay.
But I guess we'll have to wait and see until the 8th of April, which isn't far away now.
Now I think someone that happens to share the same surname as me has asked, does the court require a certified copy of the foreign judgment, and if so, by whom? And does the court require a translation of the judgment? The answer to both of those questions is absolutely yes. In some jurisdictions, it's very, very straightforward to obtain a certified copy of the judgment. In others, it's a lot more difficult. The court will definitely require a translation of the judgment and a certified translation by a, if I can use the phrase, reputable translation agency. And there's a good point on timing there as well. So there are some jurisdictions where actually getting the certified copy really can take months and months of pushing. There are others. I think we discussed DIFC yesterday, Maria, and they're
quite straightforward. You can just simply apply to the and in the United States, all the different courts have different court registry offices that you can apply to get certified copies of the judgments themselves. But you definitely need a certified copy. I mean, I've had cases where I've had to go back and say, look, we can't deal with this yet until you get a certified copy of the judgment.
Yeah. I think the final question is from Loretta again, and she says, are there jurisdictions where the limitation period is much longer than 6 years? The answer to that is yes, definitely some parts of the US. A lot of Africa has much, much longer limitation periods. I must confess, I'm not sure or can't recall the position in Russia and the Middle East, but from memory, Maria, I don't know whether you feel differently, but I think the limitation period areas are definitely a lot less strict in those jurisdictions.
Yeah, absolutely. Absolutely. Okay, well, Matthew, it looks like we're coming to our allotted time for the session. We don't want to keep everyone too much longer. So if nobody has any other questions or comments that they want to throw out there at us now, we will say thank you very much and have a wonderful, wonderful day.
Absolutely, really appreciate the time everyone's taken to join us. I hope you found it informative. I can see that at the bottom, the lovely folks at No5 have, at the bottom of the chat box, have asked for some feedback. Maria and I would love some feedback, whether it's good or bad, so we know that we're saying the right things that help you and saying the things in the right order. So thank you again from me, and please fill out some feedback. Thanks so much for joining us.
Thank you.
Cheers. Bye, everyone.